Hey everyone, Eric Rodabois. So I just did a 1-minute video where I talked about this beautiful 2.5 page, actually I'll give it credit, 3-page contract that obviously the reason we're talking about it is because there's a big dispute. So let me tell you what happened. So in this story, we've got an Argentinian company that set up a Wyoming LLC to then do business pursuant to this contract with a Colombian company that is doing business through a Colombian LLC. I'm sorry, a Colombian SAS is what it's called. So that's their type of anonymous company, which is their type of limited liability company. All right, so Argentinian guy using a Wyoming LLC, doing business with a Colombian guy using a Colombian LLC, or their equivalent. And they have a contract's in Spanish, and there's a really funny twist to the story because the reason I'm talking to the guy, and I'll tell you why there's a dispute, but the reason I'm talking to him is because he thinks that it was a US law, US jurisdiction contract, which is interesting because it's in Spanish, which by the way, that's perfectly fine. I'll just let you know that even if the judges are bilingual, which a lot of them are here in Miami, they require that everything be litigated in English. So we would have to get certified translations, and then we could run into the problem where you have competing certified translations, where the plaintiff has their version of the translation and the defendant has their version of the translation. Now, the proper thing to do, which they did not in this case, but the proper thing to do is if you intend that your contract is going to be litigated in Miami, in English, using Florida law, is you negotiate an English version of your contract. You have a clause in there that says that the English version is the one that's going to control, and then you can go ahead and make a translation into Spanish, and that might be the one that they use in their day-to-day because they're more comfortable speaking Spanish. But then we all know, and it'll even say in one of the clauses in the Spanish contract, that in the event of a dispute, the dispute will be litigated under Florida law, using Miami courts, perhaps using the English version, right? And that can all be set forth in the contract. Now, I will tell you, if the parties were more sophisticated, it would be longer than 3 pages, right? We're talking maybe 10 to 20 pages. That's probably what I would normally see in a more sophisticated transaction, where they've thought through some of these things. Hey, let's make sure that we have the contract originally in English, and then we agree that we can translate it, but that we litigate the English version if it comes to that. And so a lot of times what we'll have is on page 1 of a contract, this first part is going to talk about things like money, services, delivery, performance, time, and these are all the things that the businessmen and women will negotiate with each other. So how much, when, and what am I going to do for it, right? And that'll all be set forth. That's page 1 usually, page 1 or 2. The last couple pages, that's the lawyer stuff. That's the stuff you really only need to look at until you're in a fight, which too many business people ignore the last pages because all they are is they're excited about the first page. They're excited about the money. They're excited about the opportunity. They're excited about all the great things they're going to do together. What they forget is the entire purpose of a contract is not for all the happy stuff on page 1. It's for all the angry stuff on page 5 and page 8 or page 10. And what I mean by that is the day that you're in a fight because you didn't get paid, because the services didn't live up to the expectation that you wanted, and now you're upset, and now you're not talking to each other, and you're sending each other WhatsApp messages, and they're not getting answered. So you finally end up with a lawyer. The lawyer's they don't start on page 1. The lawyer's gonna start on the last page. In this case, page 3, although I wish it was page 10. And so the first thing I'm looking for is dispute resolution. All right, what's the law? Where are we going to do this? You know, does it say whether there's an arbitration? And kind of one of the most important things in my world is there an attorney's fee clause? Well, this one is bad. There's no choice of law. So what law applies? Is it going to be Colombia? Is it going to be Argentina? Is it going to be Wyoming? Actually, I can't see why it would be Florida because actually they don't have a choice of law. They don't have a Miami jurisdiction. The guy was surprised. He's like, oh, I thought it said Miami. I'm like, dude, you didn't read your own contract. And by the way, I'm talking to the guy that wrote the contract. It was his contract with his business. The other guy sent him a demand letter because the other guy claims he wasn't paid for services rendered. So now we're defending potentially. And I'm like, well, man, I don't know why you're talking to me because it doesn't say Florida. It doesn't say Miami. And in fact, you know what it does say? Even though it doesn't say choice of law, it says the place will be Buenos Aires. So I'm speaking to the Argentinian who lives in Buenos Aires. I'm like, dude, you need to talk to a Buenos Aires lawyer. You don't need to talk to me. And for that matter, you know what you should do is you should throw this away. Obviously, hopefully we can resolve the dispute with the guy now, and then you should hire me to actually do it the right way, where it's going to be a much stronger contract. It's going to have dispute resolution. It's going to have attorney's fees. It's going to say Florida. It's going to say Miami, if that's where he wants it. And hopefully it'll never be needed, but if it is needed, let's make sure it's something useful. So hopefully that answers a few questions, guys. Please leave a comment below or reach out to me directly if you have anything, and maybe we can talk about something similar soon.